non-assaultive. Council Douglas, recommendation, please.
Your Honor, Ms. King's CPL is recently expired, so people aren't going to object to 2,500 personal.
No objection, Judge.
All right. Ms. King, you're gonna get a $5,000 personal bond. Nobody has to pay any money for you to go to jail, for you to get out of jail. Just go to court, handle your matters. Do you understand that, ma'am?
Yes, ma'am.
Okay, good luck. DDC, can you call us on the mail side?
We're still working on the mail.
I'm sorry. What'd you say?
We're still working on the mail.
So am I.
DDC, can you tell me how long?
I don't know. I'm over here with you guys. I
Okay,
gotta go back over there.
all right, thank you. Council Reagan?
Yes, Your Honor.
Okay. We went through the females to give you extra time.
Yes, we did, Judge.
I know. So,
Yes.
yes, ma'am?
What is this just gonna say? I just-
Okay, so, can you give me a time frame, Council Reagan?
I could give you a time frame. Yes, I could, Your Honor. But if I'm off a little bit, I don't want you to hold me to that. It's
You
one-
always hold me to whatever I say.
Well, you're right about that. So maybe I'll just not give you a time frame. I'll just say shortly. Shortly.
Not too short. I got finished too.
Okay. Thank you.
You gotta let me finish. Okay, shortly.
Thank you.
No, I'm gonna walk out. You told me.
Council Reed?
You have a Jesse Clanton on your docket for today?
Who?
Jesse Clanton, he just got arrested today. I don't know, but they had a warrant.
Trenton with a T?
Yes.
T is in time, no, sir.
Beg your pardon?
No.
Okay. Thank you for checking. I guess maybe tomorrow. You join them tomorrow also?
Yes, sir, and Monday also.
You working hard. All right, I'll clue in tomorrow. I'll walk out the
Thank
pulpit
you.
and I'll come and do it. Thank you for looking.
Check.
Appreciate it.
Check back where tomorrow. Check back tomorrow.
Check back tomorrow, same time or what time you think?
About noon, about 11:30.
I'll
Yeah.
do that.
All right, good brother.
All right, I appreciate you. Thanks.
Thank
baby.
you.
All right.
No problem.
Is Monday one docket?
Pardon me?
Is Monday one docket or two?
No one. It's a
One.
holiday. Court is closed, except for the arraignments.
Thank
So we
you.
do Detroit and we do Wayne County.
Are we gonna start at 12? I'm just asking because we don't have it as a holiday, so it's gonna be like 4 of us. I'm just trying to figure out when we're supposed to be here.
As I know is, it's listed as a holiday for all of Wayne County.
See, because we're not Wayne County, so we just.
Yeah.
I mean, I'm just so. Is it at 12 then?
No, whenever
today.
we're ready.
It's like today. We could. Oh yeah.
Interview.
Yeah, you're right. Yep, yep. It's like 12.
Okay,
That's-
I will let the others know. When to, thank you.
Thank you.
So right now, my
Yep. Ready to go.
How you doing, man?
Hi, you ready to proceed?
Yes,
On the
ma'am.
list?
Get started right now.
Thank you.
All right now. Okay.
Your first folder.
Yes, it is. Right.
Sir, what's your name?
Joshua Ronald Sadler.
Mr. Sadler, this magistrate at Chatham, you're here in a criminal matter, case number 250-55-87301, sir. You have an attorney?
No.
We'll bring it on behalf of Mr. Sadler, Your Honor, waive the reading stand mute. He's been advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are February 25th, 2025, probable cause conference, followed by preliminary examination. Mark, this case is pending. There's no driving of any automobiles, mini bikes, motorcycles, and you're not to possess or use any illegal controlled substances. Do you understand those bond conditions, sir?
Your Honor.
Counsel Douglas, go ahead as to bond, please.
Jennifer Douglas for the people, P72748. Your Honor, Mr. Sadler, the people wouldn't object to a 50,000 personal bond. However, we are asking for tether house arrest that allows leaving the house only for school, work, or to attend flip the script appointments. Your Honor, Mr. Sadler is currently on HIDA probation. He's been on HIDA probation since September 13th of 2024 for multiple counts from the same case. Those counts are conspiracy to commit unlawful driving away of an automobile, conspiracy to commit receiving, concealing stolen property, 20,000 or more, and then receiving, concealing stolen property, 20,000 or more, CCW, and then 3 counts of felony firearm. He was sentenced to 3 years probation with the last 6 months Wayne County Jail, with the jail possibly, the jail could be waived if he completely adheres to the probation requirements. And so, Your Honor, we do think that there is something of a danger here, in that Mr. Sadler is in a situation where he could be subjected to jail in a different case if he were to get in trouble again. And yet he allegedly was driving at a high rate of speed, Your Honor, in different areas, hitting a vehicle, continuing to drive, driving through, literally through a construction area. There's a description of police following tire prints, and that these prints show that the vehicle went through a playground and a backyard. So, Your Honor, we do think that there is some danger to the public here, and that's why we're asking for the tether house arrest. Mr. Sadler allegedly continued to drive even though the police vehicle used lights and siren, Your Honor, and despite him allegedly hitting the other vehicle and a sign, he's alleged to continue to keep driving and then get out the car, find somebody else's car to get into, and leaving the location. So, Your Honor, given all of that together, we do have concerns. Mr. Sadler is currently already on a restricted license, and I know that you said he's not to drive. What I would point out is that there's 2 conditions to his restricted license. One is he can't drive a car that requires a commercial driver's license, which isn't an issue here. The other one is no speed violations. And so here, the radar allegedly clocked him at doing 97 and a 55. So, Your Honor, with all of these allegations, we do think that there is some danger to the public with his driving in contravention to requirements that are on him. And he's already on probation with where he's required to be and flip the script. So he's having supervision, he's having people try to get him on the right track, and we have this allegation here. So we're not going to object to 50,000 personal and that this is not assaultive. However, there is a flight risk and there is a danger, we believe, and we're asking for a tether house arrest.
Thank you. Counsel Reagan?
No flight risk, Judge. He's on probation. He reports he's in compliance fully. These are allegations. I don't know about the 97 clocking on a was somebody sitting there watching somebody clocking somebody at 97. Regardless, Judge, you know, being supervised, I don't have an objection to the personal bond, Judge. I just don't think a tether is necessary. I just think a personal bond would suffice. And you tell him not to drive, I think that would be fine in this case, Judge.
Does he work, Council Reagan?
Judge, he works, he does HVAC, HVAC. He's on call. He does on call. Like when they call, they need a person to do the HVAC system. He goes when they call him. So he's an on call employee, Judge. And he's got bigger issues to worry about, Judge, with his probation. I mean, I don't know how that's going to affect it just by even being charged. These are allegations, nothing's been proven. But, you know, that's another situation he has to deal with, you know.
Thank you. Court heard the representations both sides. While Mr. Sadler is getting a $50,000 personal bond, it's also going to be placed on a GPS tether, house arrest, except for work or court appointments in this particular matter. The GPS, because the court does find that Mr. Sadler is a danger, okay? He was not supposed to be driving or he had restrictions. And in this particular matter, the allegations in the investigative report was that he was speeding. Not only that, but in this particular matter, there was also an issue that he failed to stop after collision. So again, personal bond, GPS tether, house arrest, except for work or court appointments. That concludes his arraignment. Thank you.
Your Honor, what was the second court date?
February 25th and March 4th.
Thank you, ma'am.
Sir, what's your name? Gentleman in orange?
Say your name.
Oh, Clem White.
I'm sorry, say your name again, sir.
Kenneth White.
Thank you. Mr. White, this is Magistrate Echartea. Miss Lisa, I don't have, who is this going in front of? Is this a KPS? Okay, it's gonna go back to the same judge. One says Judge Taylor, the other one says Judge Jones. And Judge Jones did in 22.
See you, Mr. White.
12062950001. 12062950001. Pardon me?
It says Judge Taylor.
Judge Taylor, thank you. Okay, Mr. White, this magistrate Echartea, your case number is 12062950001. Sir, you have an attorney?
For the record, on behalf of Mr. White, waive the reading stand mute. He's been advised of his rights.
Thank you. I'm gonna enter a plea of not guilty. Court dates are February 25th, 2025. It's a probable cause conference followed by a preliminary examination, March 4th, 2025. Both matters are in front of Judge Taylor. Mr. White, while this case is pending, in this matter, let's see what it was. You're not to possess or use any illegal controlled substances. Do you understand that, sir? Mr. White, did you hear me?
No.
Let me repeat this. Mr. White, you have court dates, February 25th, 2025. It is a probable cause conference. You have a preliminary examination, March 4th, 2025. Both matters are in front of Judge Taylor here in 36th District. Do you understand those court dates?
Yes.
Also, Mr. White, you're not to use or possess any illegal controlled substances. Do you understand that, sir?
Yes.
Okay, I will indicate that on July 12th, 2022, a warrant was issued for Mr. White and bond was set at $500 personal bond. Court doesn't have the authority to modify this matter. Council Douglas, anything else you want to say?
No, Your Honor, nothing for the people.
Thank you. $500 personal bond. $500 personal bond, Ms. Marcia. That's what it is. All right. Sir, you can step aside. Thank you. What's your name, sir?
Melvin Williams.
I'm sorry, Melvin Williams?
Yes, ma'am.
Thank you, Mr. Williams. I'm Magistrate Chuck Dasser. You're here on a criminal matter. Case number is 240-6085501. You have an attorney. Go ahead, Counsel Reagan.
Great, on behalf of Mr. Williams, waive the reading stand mute. He's been advised of the results, Judge.
Thank you. I'm gonna enter plea of not guilty. Court dates are February 24th, 2025, probable cause conference, followed by preliminary examination, March 3rd, 2025. Both matters are in front of Judge Giles. Mr. Williams, while this case is pending, you are not to possess or use any illegal controlled substances. You understand that, sir?
Yes, ma'am.
Counsel Douglas, recommendation, please.
Your Honor, Mr. Melvin Williams, the people wouldn't object to 5,000 personal as there's no allegations of distribution or manufacturing.
No objection, Judge.
Okay, thank you. Mr. Williams, you're getting a $5,000 personal bond. Nobody has to pay any money for you to get out of jail. Just go to court and handle your matter.
Yes, ma'am.
Thank you. DDC,
Yes, ma'am.
do you have a Mr. Hall?
You said Mr. Ball?
Hall,
Mr. Hall.
Hall. He's number 2 on the list.
Excuse me, just a moment, Your Honor. Hey, Woods, we got a hall? Yeah. He's not here? Thank you. Your Honor, he's not here.
Okay, thank you.
You're welcome. What's your last name? Mr. Bradley, okay. You got this.
You know, he read it out, so it should have been a Zoom if he was gonna do it. He read it out.
All right, thank you. You got more information than I do. Thank you, Counsel Douglas. Gentlemen at DDC, what's your name, sir?
Jeffrey Owen Bradley.
Mr. Bradley, I'm Magistrate Chuck Dasser. You're here on a criminal matter, case number 250-5564601, sir. You have an attorney. Go ahead, counsel.
Mr. Reagan, on behalf of Mr. Bradley, waive the reading stand mute. He's been advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are February 24th, 2025, probable cause conference, followed by preliminary examination, March 3rd, 2025. Both matters are in front of Judge Shakay. Mr. Bradley, let me give you some bond conditions, sir. First of all is you're not to possess any firearms or any other dangerous weapons. Second, you're not to have any contact with Adonis Cisco. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Do you understand those bond conditions, sir?
Yes, Your Honor.
Thank you. Counsel Douglas, this is from January 2024, a little over a year ago. Go ahead, as to bond recommendation.
Your Honor, this is from a little over a year ago. As you say, we do have some concerns given Mr. Bradley allegedly tried to hit somebody with a vehicle multiple times. Given the age of the case, the people would ask for a bond of $500 cash or surety and no contact.
Judge, I'd asked for personal bond. It is over a year old. It wasn't signed until almost a year later. There are a lot of other factors I could talk about, Judge. I think that's the biggest one. So I'm asking for a personal bond, Judge. No injuries. He said he didn't hit her at all. He was drunk, and they've been on decent terms, judging over the last year. So I mean, but no contact is the provision, and we're just asking for personal bond.
And Counsel Douglas, Counsel Reagan, you said there was some drinking involved?
He said complaint. He said complaining was inebriated. She was intoxicated. And he said he never hit her, Judge, and
Well,
took a year to sign the case. I don't know why. But that's my information. We get both sides of, Judge. We get what the hearsay document says, the investigators report one half of it, then we get another version from the other side, Judge. So we get a chance to look at both sides.
let's just make sure, Mr. Bradley, there's no drinking of any alcoholic beverages. You understand that?
Yes, Your Honor.
Okay. And Miss Douglas, has there been anything new since January of last year?
I didn't see anything new, Your Honor.
Okay. All right. Mr. Bradley, you're gonna get a $25,000 personal bond. Nobody has to pay any money for you to get out of jail, sir, but if you break your violations, Bond conditions, don't go to court when you're supposed to. Next time, bring a toothbrush because you may be looking at a monetary bond. Do you understand that, sir?
Yes, Your Honor.
Okay, that concludes your arraignment. You can step aside.
Thank you, Judge.
What's your name, sir?
Dwayne Alexander.
Mr. Alexander, this man's Magistrate Charte is a Dwayne Jose Alexander.
Yes, ma'am. Dwayne Jose Alexander.
Sir, your case number is 24061225001, sir. You have an attorney. Go ahead, counsel.
Bring it on behalf of Mr. Alexander Wade, the written stand mute. He's been advised of his rights, Your Honor.
Thank you. I'm going to enter plea of not guilty. Court dates are February 24, 2025, probable cause conference, followed by preliminary examination, March 3rd, 2025. Both matters are in front of Judge Giles. Mr. Alexander, while this case is pending, you're not to possess or use any illegal controlled substances. You understand that?
Yes, ma'am.
Okay, thank you. Counsel Douglas, this is from March 2024, non-assaultive. Give me a recommendation, please.
Your Honor, due to the age of the case and that there's no allegations of distributing or manufacturing, no objection to 2,500 personal.
No objection,
Okay.
Your Honor.
Mr. Alexander, you're gonna get a $2,500 personal bond. Nobody has to pay any money for you to get out of jail. Just go to court and handle your matter. Understand that?
Yes, ma'am.
Thank you. Good luck. What's your name, sir?
Christopher Denson.
Mr. Denson, I'm Magistrate Judge Vassar. You're here on a criminal matter, case number 25055-87701. You have an attorney. Go ahead, counsel.
Bring it on behalf of, is it Christopher Denson? Is that what you said, Mr. Denson?
Yes, sir.
Let the reading stand mute, Your Honor. Mr. Denson has been advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are February 24th, 2025, probable cause conference, followed by preliminary examination, March 3rd, 2025. Both matters are in front of Judge Robbins. Mr. Denson, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that?
Yes, ma'am.
Counsel, Douglas, this is from February 2025, non-assaultive. He has local ties. Give me your recommendation, ma'am.
Your Honor, Mr. Denson, the people are asking for a bond of 10,000 cash or surety. He has a pending case right now in Third Circuit Court. It's case number 24-006748, where he is charged with home invasion, first degree, and felonious assault. Your Honor, he was arraigned on that November 8th of 24 and is on a 50,000 personal bond with Tether. Your Honor, he just had a final conference February 11th. The date of offense here is February 13th. Your Honor, we would note that the investigator's report does reflect that Mr. Denson did in fact have a tether on. So, Your Honor, while already under supervision of a court, at least as far as bond goes, while on a tether, he allegedly had a firearm when he should not be in possession of a firearm on bond for that type of offense. So, Your Honor, he also allegedly fled from police. That's why we're asking for a money bond, because under 765.6A, he's not eligible for a personal bond. And given that he's on bond for an assaultive set of offenses, we do have concerns that he is found with a firearm, allegedly. So we're asking for 10,000 cash for surety. The tether apparently doesn't stop him from going anywhere. We're asking for a money bond.
Okay. Counsel Reagan, go ahead.
Yeah, Judge, I don't know what the circumstances were regarding him actually having this gun or having it prior to police alleging that he had it. It was my understanding it was several individuals that were all together walking down the street. You know, I don't know if you know, somebody passed him something, told him, I mean, I don't know what the situation is, Judge. I just know that he was walking down the street, not actually going out committing any type of assaultive gesture or behavior. This is alleged he had it on his possession, and they're alleging he just had it in his hand. I mean, that doesn't even, I don't even understand how that makes sense. I read these investigators reports sometimes, Judge, and I really think they just try to write them up just to get probable cause so they can say what they want sometimes. I don't know. But regardless, I'd ask for whatever's reasonable, Judge, in terms of a bond. Ms. Douglas makes a good point about him being out on bond right now. So I would ask for the least. I would ask for a nominal bond, Judge. Is what I would ask for.
Thank you. Court's heard the representations of both sides. All this charge is non-assaultive. Okay. Allegedly, him and another individuals were on the street where there was a sidewalk provided. Officers went to investigate. Allegedly, Mr. Denson had a firearm in his, let's see, where was it? From in his right hand in this particular matter. Okay. And then, let's see what else. And the police went to investigate and speak to Mr. Denson. He took off. But the thing is he's got a pending case, and it was a home invasion. Was the other charge assaultive, Counsel Douglas?
Yes, Your Honor, it was felonious assault.
Okay. And the felonious assault, was that through the use of a firearm?
You know what, Your Honor, I do not know. I know that one of the people listed as a victim is an 11-year-old, but I can check and see what the weapon was.
He has a personal
That's all
bond in the case, Judge, too. So just.
Yeah. It's got a personal bond on that, and under MCL 765.6A, personal bond, on this case, court is reading that requires a cash bond in this matter. So, the court will, using clear and convincing evidence standard, okay, because actually, could have been a danger. That's on the prior case. On this case, just a CCW running away from the police, attempting to run from the police with a firearm. Okay. Court finds him more of a flight risk than a danger. The court is going to adopt the recommendation, $10,000 cash surety. Okay. Not going to be placing him on GPS tether. He's already on that in this particular matter. But with that being said, counsel, that is unaffordable.
Yes, Your Honor.
All right, he's got another court date this Wednesday, February 19, 2025, 9 o'clock in front of Judge McConaughey. We'll look at the bond amount and bond conditions. Thank you. That concludes Mr. Denson's arraignment. Gentlemen at DDC, what's your name, sir?
Elin,
Mr. Elin, give me your full name, sir.
Bernard Antonio Elin Jr.
Thank you, Mr. Elin. I'm Magistrate Chartea. You hear the criminal matter. Case number is 250-558-7801. You have an attorney. Go ahead, counsel.
Bring it on behalf of Mr. Elin, Your Honor, waive the formal reading, stand mute. He has been advised of his rights.
Thank you. Evidentiary plea of not guilty. Court dates are February 24th, 2025, probable cause conference, followed by preliminary examination, March 3rd, 2025. Both matters are in front of Judge Taylor. Mr. Elin, while this case is pending, you're not to possess any firearms or other dangerous weapons. You understand that, sir?
Yes,
Again, this is in front of Judge Robbins. I said Judge Taylor, so let me be clear. February 24th and March 3rd, both matters are in front of Judge Robbins.
Okay.
And no firearms or other dangerous weapons. Counsel Douglas, this is for March 2025. Non-assaultive, he has local ties. Go ahead, that's the bond recommendation.
Your Honor, Mr. Elin, no objection to 5,000 personal.
No objection.
Mr. Elin, you're gonna get a $5,000 personal bond. Nobody has to pay any money for you to get out of jail. Just go to court, resolve your matter. Good luck.
Oh, it's 800 now? I didn't translate. I saw. This number one, 800.
What's your name, sir?
Warren Dean,
Kamarian Dejan Dean.
Yes.
Thank you, sir.
Kamarion Dejan.
Administrator Chuck Fair.
I'm sorry.
Thank you. Go ahead and say, you can say that again.
Kamarion Dejan Dean.
Thank you, sir. Your case number is 25055-88001. You have an attorney. Go ahead, counsel.
Great, on behalf of Mr. Dane, waive the reading stamp duty. He's been advised of his rights, Judge.
Thank you. I'm going to enter plea of not guilty. Court dates are February 25th, 2025, probable cause conference, followed by preliminary examination, March 4th, 2025. Both matters are in front of Judge Taylor. Mr. Dean, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You're not to have any contact with the Leonard Powell. When I say Powell, that means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to go back to the Elmdale residence while this case is pending. Do you understand those bond conditions, sir?
Yes, ma'am.
Thank you. Counsel Douglas, your recommendation, please.
Your Honor, Mr. Dean, the people are asking for a bond of 25,000 cash or surety with tether house arrest. We would note that Mr. Dean has a prior 2023 RNO ordinance violation out of Redford, and that he is currently on height of probation for attempt fleeing fourth degree and attempt RNO, same case, out of 37th District Court in Warren. There was a warrant issued in that case, February 6th of 2024, for failure to appear for a violation of probation hearing. And so he has been missing on that case for about a year. And Your Honor, we would note that in the investigator's report, when the officers asked him why he did not report the alleged incident that's supposed to have just happened, he said it's because he knew he had warrants. And so that would indicate that he's aware that he's supposed to have gone to court, Your Honor. And since he's been missing on that Haida case for a year, we believe that there's every reason to believe that he will fail to appear on this case, Your Honor. There is a shot spotter report and a .40 caliber shell casing, which would indicate that there was in fact some shooting going on. And so, Your Honor, we are asking for that bond for safety reasons. We're asking for 25,000 cash or surety, tether house arrest.
Thank you. Counsel Douglas, excuse me, Counsel Reagan, go ahead, please.
Yeah, Judge, I think it's just the opposite. My client allegedly went over with his girlfriend to her dad's house. This is her girlfriend's dad, to get some of her items. And she was aggressively trying to get in the house. My client said, you know what, this is too much. It's time to go. So, but allegedly, once he says, oh, it's time to go, he supposedly pulls out an AR-15 and starts shooting. That doesn't even make sense, Judge. And the complaining witness is going to even say that her own dad was shooting at her. The dad was shooting at them. The Ring cameras is going to tell it all, Judge. Once the Ring cameras come, it's going to show. I think that, because he might have had some other stuff going on, they arrested him. They decided to charge him. I don't even know who signed this warrant. Somebody not. Okay. But I'm just saying, Judge, a lot of times they hit one side of the story until they need to really look at everything and look at all the stuff first before they sign, I think. And I think in this situation, a lot of it's going to come out. I can't speak on the Haida stuff in Dearborn, on the Capia stuff. I can't speak on that. I can just say on this situation, Judge, and just talking in depth with Mr. Dean, talking about what the evidence is going to show, what he's very confident about. I would ask for a personal bond, whatever conditions the court wishes to impose, Judge. This court has wisdom, but I don't think that my client is going to go back over to his girlfriend's dad's house. I don't think he ever went over there with the intention of doing anything, Judge. So I'm asking the court for personal bond, Judge.
Thank you. I've heard the representations, both sides. In this particular matter, court uses clear and convincing evidence standard. After hearing the recommendations, the arguments, and a review of the investigator's report, the allegations in there, court's going to adopt the recommendation. The court does believe that Mr. Dean is a danger. I do believe also there's an issue of self-defense issue, but that is a trial court matter. But in this case, $25,000 cash surety. And Counsel Douglas, I want to make sure, what was the argument? I believe you wanted a GPS tether?
Yes, Your Honor. It's because he has, on his height of probation, he failed to appear for a violation of probation hearing, and that's what he has a warrant for. He told officers the reason he didn't report the incident is because he has warrants. He has what he has a warrant for failing to appear for violation of probation since that warrant is from February 6th of 2024. So an entire year he's been missing on his probation case. So I think there's a flight risk.
Uh, Accept that also, adopt that part of the recommendation, GPS tether. And Council Douglas, not Council Douglas, Council Reagan, does he work or not?
Judge, he works as a mechanic, his hours vary, so I'm asking for I don't think a tether is necessary in this case, but he does work, Judge, as a mechanic, that's correct.
Works for a mechanic, is he, works with a mechanic, is he an employee of a car dealership, a car repair shop, or he just works for a mechanic?
He's freelance, is that correct? He's freelance, is that correct? He's just a freelance mechanic, Judge.
In this particular matter, I'm gonna place him on GPS tether house arrest unless he has sufficient information further to indicate other than the freelancing. So GPS tether house arrest, $25,000 cash for surety, which I believe is unaffordable. Is that correct, counsel?
Yes, Your Honor.
Okay. That means he's gonna get another court date for this, this Wednesday, February 19th, 2025, 9 o'clock in front of Judge McConicle, who'll look at the bond conditions as well as bond amount. That concludes your arraignment, Mr. Dean. Danger and flight risk.
Sit down.
What's your name, sir?
I yell Dion Ashford.
Mr. Ashford, this is Magistrate H. Faster. You have 2 criminal matters. Let me give you the first one is case number 250-55-88201. Date of offense is February 12th, 2025. And the second case number is 250-55-88101. And that date of offense is January 29, 2025. If you have an attorney, go ahead, counsel.
Your Honor, made on behalf of Mr. Ashford, waive reading as to both matters. He has been advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Same court dates, Mr. Ashford, is at February 24th, 2025, probable cause conference, followed by preliminary examination, March 3rd, 2025, both matters in front of Judge Shakay. Mr. Ashford, let me give you some bond conditions. You are not to have contact with Charlize Oliver. That means
Yes.
no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You are not to possess any firearms or any other dangerous weapons. Also, sir, you are not to go to these 2 locations. Excuse me. You're not to go to these 2 locations, 2945 West Grand, believe, Street, as well as 7058 Chalfont, both in the city of Detroit. Do you understand those bond conditions, sir?
Yes, ma'am.
Thank you. Counselor Douglas, go ahead with your bond recommendation.
Your Honor, Mr. Ashford, people are going to ask for both cases. We're going to ask for a bond of $25,000 cash and surety of tether house arrest for the following reasons, and please bear with me because it's a little bit long. Mr. Ashford was here in court yesterday, and I had his arraignment on a KPS, Your Honor, with the same complaining witness, a DV case with the same complaining witness, Your Honor. With that case, that's a 24 case where he was arraigned December 2nd of 24. He was given a $10,000 personal bond, tether house arrest, Your Honor. He then appeared at one pretrial December 12th, but then failed to appear at pretrial January 9th of 25. He was eventually arraigned yesterday, Your Honor. So even though he had a tether and allegedly with house arrest, he somehow was missing for over a month on this DV case with the same complaining witness. Now, I bring this up because yesterday, these 2 cases weren't in our system. And so I wasn't aware of them. The magistrate asked me, had anything happened since he'd been missing? And I said, no. I had asked for the $500 cash bond to stay in place. He was given $500 personal the tether without any restrictions besides no contact, which is actually a lower bond than he had in the first place when he was originally arraigned. I would note that although I did ask what happened to his tether, because it doesn't make sense that he was at this lady's house if he had his tether on. And there was, in fact, a tether order, which was confirmed by the magistrate. And we still don't know what happened to his tether because he's supposed to have no contact. And I would note that the complaining witness's address in that case is the same as what her address was at the time of the January 29th, 25 incident. So that tether should have gone off if he had that tether on. We still don't know what happened to the tether. And so a personal bond with the tether would be absolutely ineffective. He's not supposed to be having any contact with this lady, Your Honor. And yet we have him seeing her twice while he is capious on a DV case where she is a victim, Your Honor. And both of these are assaultive cases. Your Honor, they have had multiple prior cases where she's failed to appear, but there's a number of reasons why people may fail to appear, including fear. Here, he's allegedly breaking into her house, assaulting her, at a different time, choking her into unconsciousness. And so, Your Honor, when we have someone who allegedly has a PPO that was served May 11th, 24, still going to her and allegedly assaulting her, has cases where he's ordered not to have contact with her and given a tether, and yet he's still allegedly going over and assaulting her. It would be understandable why she may be afraid. And so, Your Honor, what we are asking for at this time is $25,000 cash or surety, tether, house arrest in both cases. We would note with the home invasion case, Mr. Ashford allegedly forgot his cell phone at her home, which would be corroboration that he was there. So, Your Honor, when the magistrate asked, how did Mr. Ashford come to be in custody for the KPS, the answer was he was walking down the street and the police approached him, which apparently is technically true. But the reason they approached him is because they were trying to arrest him for assaulting the complaining witness again. And so, Your Honor, at this time, that's what we're asking for. $25,000 cash or surety, tether, house arrest for both cases.
Thank you. DDC. Ma'am?
Yes, Your Honor.
Can you tell me, does Mr. Ashford, does he have a GPS tether on his ankle?
No.
No, Your Honor.
Thank you. Go ahead, Council Reagan.
Judge, one, my client didn't know about any active PPO. There's no active PPO in place to his knowledge. Secondly, Judge, there's more than one reason why somebody doesn't come to court, is not cooperative. Ms. Douglas says she might be afraid, but also, Judge, maybe it's because they didn't tell the truth in the first place. That's why they're not coming to court. That's why they're being uncooperative. And it's my understanding she's still being uncooperative in these two cases, let alone the past cases. So, you know, I don't know about the likelihood, Judge, because she's not being very cooperative now with detectives. But my client, Judge, I think with a personal bond and a tether, it could suffice, Judge. And Ms. Douglas says we don't think so because there was a previous tether. I don't know about a previous tether, Judge. I just, you know, I'm looking at these two cases. Even the case yesterday, Judge, there was a personal bond given. And I know Ms. Douglas says she didn't realize about these cases. Well, I mean, you know, there's some issues we have going on here, and I don't think the issues are really with Mr. Ashford, Judge. I think it might be with another situation. But regardless of that, I'm asking for the personal bond, no contact, whatever you wanted to do, Judge, is conditional. We understand because there's more than one case. But again, Judge, he didn't know anything, you know, about a active PPO. He knows nothing about that, Judge.
Well, Your Honor, the lien says it was served, and I would note that yesterday, Magistrate Dafia Burton looked in the file and said that there was an order for a tether in that case. So he was ordered to have a tether. The court can right now look up the case on the court's website. He was ordered to have a tether.
Hey,
I'm not saying Ms. Douglas is wrong.
all right, folks, thank you. What I want to ask is, all right, Council Douglas,
Yes, Your Honor.
I want to make sure that I understood this. Was there a KPS on a DV
Yes, Your Honor.
that he was arraigned yesterday?
Yes, Your Honor.
Okay. And when was that case from? Last year?
Yes, Your Honor, the date of offense was November 30th of 24. It was authorized December 2nd of 24, and he was arraigned that same day, December 2nd of 24.
Okay. And so he was basically given a personal bond on that case, correct?
Yes, Your Honor. I had asked for the
Okay.
500. Oh, sorry. Okay,
That's, that's fine. That's fine. Okay. I just wanted to make sure, okay, the court has heard, so he's got a prior pending case, DV, same complainant. He's got a personal bond. He's got two cases, one from January 29th this year, the other one from February 12th this year. And I know whoever arraigned him or initially arraigned him told him not to have contact, even if it's not contact, no assault of contact with the complainant. And in this matter, both cases, it looks like it's been escalating. However, issues, whether he did or did not, those are trial issues in this particular matter. Court uses clear and convincing evidence standard. When it's entertaining monetary bond, we start off personal bond basis. And that's what I was looking at until I started reading more information and hearing the arguments. Okay, this court does find Mr. Ashford is a danger, flight risk, as well as a danger in this particular matter. Okay, court is going to adopt the recommendation, $25,000 cash surety for each case. Court is also going to put down, he's going to be placed on a GPS tether house arrest for both matters. And the course is, Council Reagan, this is unaffordable, is that correct?
Yes, Judge.
Okay, so Mr. Ashford, this court is not the decision is not the last word. You're going to get another court date for this Wednesday coming up next week, February 19, 2025, 9 o'clock in front of Judge McConicle, who'll look at the bond amount and bond conditions.
Okay.
Thank you, sir. That concludes your arraignment.
All right, thank.
Your Honor, I heard from Mr. Perkins. He didn't realize that Mr. Hall was on the docket, but he said he can get on Zoom by 3 o'clock.
We're doing arraignments. These are in custodies.
Okay.
Okay, well, I appreciate that information. Thank you.
So Judge, just want to make sure
Gentlemen,
a warrant's not going to go out for Mr. Hall. I mean, I know that. I just want to make sure because I think we have the file and it was scheduled. I mean, it's on here today, so I don't know. Just want to make sure.
I don't have a file,
Oh,
Council
you don't have a
Reagan.
file.
We're only doing the in custodies.
Yes, ma'am.
Oh,
Yes,
what
ma'am.
was the first name?
Number 2 on the
Mr.
list.
Paul,
On the list.
They got a file right here.
Yeah. 'Cause it's-
we only do in custodies.
Okay.
Thank you. All right, gentlemen at DDC, what's your name, sir?
Davon Cole.
Davon Patrick Cullum, sir?
Yes.
Thank you. Mr. Cullen, I'm Magistrate at Charter. You hear the criminal matter. Case number is 250-55-88301, sir. You have an attorney. Go ahead, counsel.
Right on behalf of Mr. Cullum, Judge, waive the reading stamp duty. Has been advised of his rights.
Thank you. I'm gonna enter a plea of not guilty. Court dates are February 24th, 2025. It is a probable cause conference followed by a preliminary examination, March 3rd, 2025. Let's see if I have any paperwork. This is going to be in front of Judge Giles. Mr. Cullum, while this case is pending, you are not to have any combative or assaultive behavior. Do you understand that, sir?
Yes.
Okay. Counsel Douglas, I see that he has local ties. This is from February 2025. Go ahead with your bond recommendation, ma'am.
Your Honor, the people are going to ask for a bond of $500 cash or surety. The reason we're asking for that is we do think that there is a danger here. Mr. Cullum allegedly told police that he did not realize that the person he was in a scuffle, quote unquote, scuffle with was a police officer, which we actually find slightly more concerning. Usually the statement made when a person has an RNO is the person got afraid because it was the police and that's not how they would normally act. Here, Mr. Como allegedly thought this was just a regular person at their job who had asked him to leave and told him to leave multiple times. And then he's allegedly trying to fight this person with the help of another. And so, Your Honor, we do think that based on that, there is a danger here. That's why we're asking for the $500 cash or surety. As far as priors go, I didn't see any prior convictions. I just saw a 2017 HIDA for AWIM, unarmed robbery, and GBH is what his lien said.
The convictions or just arrests?
It's a HIDA. It says HIDA dismissed for AWIM, unarmed robbery, and GBH is what the lien says.
When? What year?
2017.
Okay, thank you. Council Reagan, go ahead, please.
Asking for personal bond, Judge. No criminal convictions, no criminal history. He's a supervisor at the post office. It's a 2-year RNO. I'm just asking for a personal bond, Judge.
McCollum, you understand when the court says no assault or combative behavior?
Yes.
All right. And sir, that just doesn't mean with police officers. It means with anybody else in the public. Do you understand that?
Yes.
You can't get and say, make me leave or I will beat you outside. I don't want to respond, sir. But the allegations are supposedly you got into somebody's face, they're asking you to leave, okay? And allegedly something to the effect that, okay, I will see you outside, I will catch you outside, okay? Meet me outside, I will see you outside the gate. Sir, walk away. Otherwise, you're gonna be looking at a criminal charge. Do you understand that?
Yes.
I'm giving you one chance, sir. You're gonna get a $50,000 personal bond. Nobody has to pay any money for you to get out of jail. But I'm also telling you, let's go. Let me see. You are not to go back to that location, 10750 Grand River Avenue. Do you understand that?
Yes.
If you violate, sir, bring a toothbrush because you may be looking at a monetary bond next time. Do you understand that? Okay, that concludes your arraignment. You can step aside. Stand by, sir. Gentlemen at DDC.
Say it again.
What's your name?
Tony Patterson.
Is it Tony James Patterson Jr., sir?
Yes, ma'am.
Thank you, sir. I'm Magistrate Chavathea. Your case number, sir, it is 24059786001, sir. You're here. You have a defense counsel. Go ahead, counsel.
Right, on behalf of Mr. Patterson, waiver reading stamp mute. He's been advised of his rights, Judge.
Thank you. I'm an entry plea of not guilty. Court dates are February 24th, 2025, probable cause conference, followed by preliminary examination, March 3rd, 2025. Both matters are in front of Judge Giles. Mr. Patterson, while this case is pending, one, you're not to possess any firearms or any other dangerous weapons. You're not to go to the Seaway Market located on West Chicago. No assault for combative behavior. Do you understand those bond conditions, sir?
Yes, ma'am.
Okay. And Counsel Douglas, go ahead with your recommendation.
Your Honor, this dates to October 24. So a few months ago, the people would ask for a bond of $5,000 cash or surety and no contact. Normally with this kind of case, we might ask for something higher, but given the allegations, Mr. Patterson actually took the weapon from the other accused and put it out of harm's way, Your Honor. And so he de-escalated what would have been a very, very dangerous situation. So that's why we're not asking for a much higher bond. So we're asking for 5,000 cash assured.
Council Reagan?
Why he gets, or let me ask you, or Judge, the co-defendant, the case was dismissed against her back on the 5th of October of 24. It was dismissed at the exam. I'm sorry, it was on the 25th of October. So that the complaints, this co-defendant's case has been dismissed. So I'm just asking for personal for Mr. Patterson, Your Honor, in this case, since he de-escalated it.
Thank you. Council Douglas, do you have anything new since the date of offense?
No, Your Honor, and I didn't see any priors either.
Okay, so, Mr. Patterson, you're gonna get a $50,000 personal bond. Nobody has to pay you money for you to get out of jail. Please obey the bond conditions and go to court and resolve your matter. Do you understand all that, sir?
Yes, ma'am.
Good luck. You can step aside, sir.
Yeah, thank you.
What's your name, sir?
Deshaun Lewis.
Is it Deshaun Demetrius Lewis, sir?
Yes.
Thank you, sir. I'm Magistrate in charge there. Your case number, sir, is 250-55-88401, sir. You have an attorney. Go ahead, counsel.
Well, right, on behalf of Mr. Lewis, waive the reading, stand mute, Your Honor, he's been advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are February 25th, 2025, probable cause conference, followed by preliminary examination, March 4th, 2025. February 25th, March 4th, preliminary examination. Both matters are in front of Judge Jefferson. Mr. Lewis, you understand those court dates?
Yes.
Also, Mr. Lewis, while this case is pending, there is no driving of any automobiles, mini bikes. Do you understand that?
Yes.
Okay. Council Douglas, go ahead.
Your Honor, Mr. Lewis, the people wouldn't object to a 50,000 personal, but I am asking for tether house arrest. The information I have is that Mr. Lewis currently has another case pending out on Grosse Pointe Woods where he failed to appear for exam at the end of last month, and that a $250,000 capias bond was issued. That's a case for UDAA. Your Honor, the note I see in the file is that all of the witnesses appeared for the exam, but Mr. Lewis did not. So, Your Honor, we do think that given that he failed to appear in his other case, that here he's allegedly fleeing police, we do think there's definitely a flight risk. So we are asking for tether house arrest, but I'm not going to object to a personal. He still has to deal with that 250,000 bond out in Grosse Pointe Woods.
Excuse me, I'm sorry. Council Reagan, go ahead.
Judge, I don't know anything about Grosse Pointe out there. I have no clue about anything. I just know this case is as a fleeing third. I'm asking for personal bond, Judge. It's non-assaultive. It's a five-year felony. I do get he has a prior 2014 larceny. I can see that, but I don't know anything about any other jurisdiction or anything like that. I am asking for personal in this case, Judge.
Okay. Well, he's going to get a $50,000 personal bond. And Council Douglas, you said it was last month, failed to appear?
Yes, I think it was January 29th.
And what was the charge?
It's unlawful driving away of an automobile. And then
There's
there
a
was,
judge.
it sounds like Mr. Lewis
Right.
could tell us.
Okay, yes, I know. Mr. Lewis, you don't need to give us any information. Thank you. Okay, if he's got capias bond from another case, then I'll let that court deal with it. $50,000 personal bond. I'm not going to place him on a GPS tether. Let the court deal with that.
Thank you, Judge.
Thank you. Thank you. Can you step aside, sir?
Let me know.
What's your name, sir?
Gregory Martin, ma'am.
Is it Gregory Deshaun Martin?
Yes, Your Honor.
Thank you, Mr. Martin. I'm Magistrate Chatterthea. You're here on a criminal matter, case number 250-5588511. You have an attorney. Go ahead, Counsel Reagan.
Lorraine, on behalf of Mr. Martin, waive the reading, stand mute. He's been advised of his rights, Judge.
Thank you. I'm going to enter a plea of not guilty. Court dates are February 25th, 2025, probable cause conference, followed by preliminary examination, March 4th, 2025. Both matters are in front of Judge Taylor. Mr. Martin, while this case is pending, you're not to possess any firearms of any kind. You're not to possess any ammunition of any kind. Do you understand those bond conditions, sir?
Yes, Your Honor.
Thank you. Counsel Douglas, go ahead, please.
Give me just one moment.
Okay, thank you. DDC,
Yes, Your Honor.
can you tell me, is there a hold on Mr. Martin?
No, Your Honor.
Okay, thank you.
Your Honor, on Mr. Martin, the people would ask for a bond of 25,000 cash or surety. The reason we're asking for that, he is currently on probation for attempt CCW. Your Honor, that it's out of Macomb County. He just got sentenced April 10th of 24. He has assaultive priors, and those include involuntary manslaughter. And I know that the court is able to see the HAB notice on Mr. Martin's investigator's report. So, Your Honor, given his prior convictions, we do have some concerns about safety. He should not be in possession of a weapon, and given what his prior convictions are, that gives us concern for the safety of the public. For him to be on probation for a firearm offense, for him to have prior assaultive offenses, and then allegedly be in possession of weapons again, Your Honor, that is why we're going to go ahead and ask for a money bond of 25,000 cash or surety.
Was there any assaultive behavior in this case, Counsel Douglas?
Your Honor, he's not charged with any assaultive behavior, but he shouldn't be in possession of a firearm if he's on probation for possession of a firearm. There was a single round shot spotter alert, sounds like. But it's not clear that necessarily who is shooting. But Your Honor, given that he's not supposed to be in possession of a firearm at all, we do think that there's a safety issue.
Okay. Is there anything to indicate that he has not shown up for court?
Your Honor, I'm not aware of any failures to appear.
Okay, thank you. Counsel Reagan?
Because you know, the great thing about this is that, you know, that line they say in voir dire when they're asking the jury, without anything being said, if you would have to come back with a verdict right now, what would you come back with? Not guilty? Because he's not guilty, Judge, until they prove he's guilty. This is just a simple possession, alleged possession of the firearm. No, like Ms. Douglas said, no assaults, no nothing. And we don't know if he actually did possess it, Judge. That's going to come out later. Right now, he's on probation in Macomb. You got to deal with whatever issues that comes with, Judge. I don't, you know, the past is the past. He does have some history, but I don't know what happened exactly in this case, and it'll come out during the course of the case. Right? I just think today, because there's no assault, I'm asking for a personal bond. I think a personal in this case can suffice, Judge.
Okay. Well, the court heard the representations. I read the allegations. Okay. Allegedly, officer spoke to Mr. Martin, who ended up retrieving an extended magazine for his firearm. It appears that he was invited into the home. I mean, officers were invited into the home. I don't see anything to indicate there was combative behavior. So, Mr. Martin, you're going to get a $50,000 personal bond. Sir, if you violate the bond conditions, don't show up for court. Next time, you're going to be looking at a monetary bond. Do you understand that, sir?
Yes, Your Honor.
All right. Go to court, handle your matter, sir.
Thank you, Your Honor.
Yes, sir. Lisa, can I see the Lewis file for a moment?
Lewis.
Yes, that was the one before Mr. Martin. A moment. Can I see the mint? I just need to make sure I'm on matter. Yep, thank you. Here you go, Miss Lucy. All right, sir, what's your name?
Aaron Armstrong.
Mr. Armstrong, Magistrate at Charter, sir. You're here on a criminal matter, case number 250-55-88701, sir. You have an attorney. Go ahead, counsel.
The record on behalf of Mr. Armstrong, Your Honor, waive the reading stand mute to be advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are February 24th, 2025, probable cause conference, followed by preliminary examination, March 3rd, 2025. Both matters are in front of Judge Shakay. Mr. Armstrong, let me give you some bond conditions, sir. Okay, you're not to have any contact with Sheree Ellis. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. Sir, you're not to possess any firearms or any other dangerous weapons, and you're not to go back to the Hoover residence. Do you understand those bond conditions, sir?
Yes.
Thank you. Counsel Douglas, go ahead with your recommendation.
Your Honor, with Mr. Armstrong, I'm not going to object to 50,000 personal. I would ask for no contact with the complaining witness, which you've already addressed, no contact with the location they appear to live together. Your Honor, I don't see any prior assaultive cases on his lien. And so, Your Honor, given the allegations, I believe that if there's no contact, that would be sufficient to ensure safety here. So I'm not going to object to 50,000 personal with no contact.
Thank you.
Objection, Judge.
Thank you. Mr. Armstrong, you're going to get a $50,000 personal bond. That means nobody has to pay any money for you to get out of jail. Just go to court, handle your matters. You understand that, sir?
Yes.
Good luck, sir. You can step aside. What's your name, sir?
Dewan Green?
Juan Jacoby Green?
Yes.
Mr. Green, I'm Magistrate at Charter. Your case number for your criminal matter is 250-55-88601, sir. You have an attorney. Go ahead, counsel.
Record on behalf of Mr. Green, waive the reading stand mute. You've been advised of his rights, Your Honor.
Thank you. I'm gonna enter plea of not guilty. Court dates are February 24th, 2025. It is a probable cause conference followed by preliminary examination, March 3rd, 2025. Both matters are in front of Judge Shakay. Mr. Green, let me give you some bond conditions. You're not to have contact with the complainant. I think it's Maya Green. That
Yes.
means no person-to-person contact, sir. No contact to third parties, no phone calls, no emails, no text messaging. You're not to go back to the Hickory residence, and you're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes.
Okay. Go ahead, Counsel Douglas, with your recommendation.
Your Honor, we do have concerns for safety, given that this is a DV third. Given the allegations, though, we do believe that your no contact order could be sufficient to ensure safety. So, Your Honor, I'm not going to object to a 25,000 personal since there is a no contact order with the location and the complaining witness.
No objection, Judge.
Mr. Green, court is going to adopt the recommendation. You're going to get a $25,000 personal bond. Nobody has to pay any money for you to get out of jail. Court also looks at that even though he has some prior domestic violences, the last one is more than 10 years ago, 2013. So again, $25,000 personal bond, Mr. Green. Just go court, handle your matter.
Thank
You
you.
can step aside, sir. What's your name, sir?
Earl Richardson.
Jarrell Melvin Richardson?
Correct, I'm sorry.
That's all right. Mr. Richardson, I'm Magistrate Chartea. Your case number is 250-55-88801. You have an attorney. Go ahead, Counsel Reagan.
Magistrate Laura. Your Honor, Philip Reagan on behalf of Mr. Richardson waived the reading stand mute. He's been advised of his rights.
Thank you. I'm going to enter plea of not guilty. Court dates are February 24th, 2025. Probable cause conference followed by preliminary examination, March 3rd, 2025. Both matters are in front of Judge Giles. Mr. Richardson, while this case is pending, you're not to possess any firearms of any kind or any other dangerous weapons, as well as no ammunition of any kind. Do you understand those bond conditions, sir?
Yes, Your Honor.
Okay. All right. Counsel Douglas, go ahead with your recommendation.
Your Honor, this is non-assaultive, and so given that the people aren't going to object to a personal bond, he does have some priors. However, given that this is a traffic stop, there's no allegation of an attempt to use the gun. I'm not going to object to a personal.
No objection, Judge.
Thank you. Mr. Richardson, you're going to get a $25,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you understand that, sir?
Yes, ma'am.
Go to court, handle your matter. Good luck.
Thank you. You all have a great day.
Thank you, Your Honor.
Your Honor, that was 25,000.
Yes, $25,000 personal bond.
Thank you, Your Honor.
Yes, ma'am. What's your name, sir?
Mukhtar Landrum.
Can you give me your full name, including your middle name?
Mukhtar Suja Landrum.
Thank you, Mr. Landrum. Sir, you're defendant one in this case. Your case number is 250-55-88901. You have defense counsel. Go ahead, counsel.
Your Honor, Philip Reagan on behalf of Mr. Landrum waived the reading stand mute. He's been advised of his rights.
Thank you. I'm going to enter plea of not guilty. Court dates are February 25th, 2025. It is a probable cause conference followed by preliminary examination, March 4th, 2025. Both matters are in front of Judge Jefferson. Counsel Douglas. Oh, hold on before that. Mr. Landrum, while this case is pending, you're not to possess any firearms or any ammunition of any kind. Do you understand both bond conditions?
You said I'm not to have any firearms or ammunition. Yes, I heard that.
Okay, thank you, sir. Go ahead, Counsel Douglas.
Jennifer Douglas for the people, Pete 72748. Your Honor, Mr. Landrum, I am asking for $1 million bond. Normally, I don't ask for bonds like that, Your Honor, but here we have an allegation that Mr. Landrum is alleged to have shot at police, shot out of a house when court bailiffs were attempting to do an eviction, and that police were present to stand by. Your Honor, there was an individual who actually got shot twice, had to be treated at the hospital. And when officers were able to go into the location, finally, they found large amounts of ammunition, multiple firearms, and Your Honor, a ballistic vest and helmet. Mr. Landrum allegedly was wearing a bulletproof vest, which would indicate that he was prepared to do some sort of shootout. Fortunately, there was no more shooting besides that, Your Honor, but this was a situation that could have ended up in the deaths of multiple people. And so, Your Honor, given that this is a situation where Mr. Landrum is accused of basically shooting at court bailiffs, one of the workers and officers who are standing by, we do think that there's a grave danger to the public when we combine that with Mr. Landrum allegedly being in a bulletproof vest and with a ballistics helmet available inside, Your Honor. So that's why I'm asking for that bond for him.
Go ahead, Counsel Reagan.
So I don't know about, how police were standing by. I don't know about that. I do know that, obviously bailiffs, they do a great job in terms of going out, and obviously it's dangerous at times. Now, in this particular situation, and my client says that he did not understand or realize, he thought somebody was breaking in his house. I think they used force to go in. The door was pried open. And, I don't know, again, I wasn't there, Judge, but, he tells us, he thought someone was breaking in. Now, obviously, this case has to go through the process. I never, ever want to see anybody obviously shot or hurt or injured in any situation. It's unfortunate, Judge, but the facts are going to come out throughout the case. Right now, we're just determining bond. If you tell him to not possess ammunition or guns, he's not going to do it. He's got to obviously stay away from the complaining witnesses. So I don't know I think $1 million bond is excessive, Judge, in this particular situation. I'm asking for something more reasonable. Again, Judge, his state of mind at the time was different than I think what the investigator's report talks about or reads. So I think, once this case again matriculates through, it'll come out, more information will come out. So I'm asking for a more reasonable bond. I think $1 million is excessive, Judge.
Thank you. Courts heard the representations, both sides. Court uses clear and convincing evidence standards when it's considering a monetary bond. In this particular matter, court had the opportunity to read the allegations, and this looks like court officers were, as bailiffs, were trying to do an eviction on Stahalin in this particular matter, that they announced that they were bailiffs. Okay. And then they proceeded to try to open the door. One of the workers was shot. He was shot in the arm and leg, ended up going to the hospital. There were a number of, rifle casings that were in the hallway. There was a lot of ammunition for shotguns, handguns, and rifle. There was shotgun found. There was a handgun found. Allegedly also that this defendant, he had on a bulletproof vest. Okay. As to the issue, if somebody was breaking in, okay, that is an issue for trial court. But in this particular matter, the court is going to adopt the recommendation, $1 million, cash surety. We're also going to get a bond redetermination for this Wednesday, February 19, 2025, 9:00 in front of Judge McConigal.
Thank you, Judge.
Thank you. You can step aside, sir. What's your name, sir?
Ashby Timo Landrum.
Your full name, including your middle name.
Ashby Timo Badinu Landrum.
Thank you, Mr. Landrum. Mr. Landrum, I'm Magistrate Chartea, sir. You are defendant 2 in this case, case number 250-5588902. You have an attorney, Counsel Reagan. You waive formal reading and stand mute.
Yes, Your Honor.
Okay, Mr. Landrum, your court dates are February 25th, 2025. It is a probable cause conference followed by preliminary examination, March 4th, 2025. Both matters are in front of Judge Jefferson. Mr. Landrum, this case is pending. You're not possess any firearms of any kind or any ammunition of any kind. Do you understand those bond conditions, sir?
Yes.
Thank you, sir. Counsel Douglas?
Jennifer Douglas for the people, P72748. Your Honor, while I'm going to ask for a money bond on Mr. Landrum, I'm not going to ask for as high of an amount. I would point out that Mr. Landrum was not found with any sort of bulletproof vest on. I would note that he seems to have come out of the house pretty quickly as opposed to the other Mr. Landrum. And I didn't have a chance to shoot Mr. Reagan an email, but I did see on the lien that this Mr. Landrum has had 2 mental orders in the last couple of years. He had one from 2022, March of 2022, for involuntary hospitalization or alternative treatment. And then the most recent one is actually January 3rd of 2025, a mental order. And it indicates due to mental illness that he is unable to attend to basic needs or understand that he needs treatment. And so we do have concerns there that Mr. Landrum is perhaps at some point, I'm going to assume there's going to be a referral on this, Mr. Landrum. So while I would ask for a money bond, I would ask for 100,000 cash or surety. I'm not asking for the other amount, seeing as how he's had 2 mental orders and one very recently requiring involuntary hospitalization for mental treatment.
Okay, DDC,
Yes, Your Honor.
can you mark this gentleman's file medical?
Yes, Your Honor.
Thank you. Council Reagan, go ahead, please.
Judge, and the report doesn't talk too much about this Mr. Landrum. It talks about him coming to the house about a week ago and moving in with his brother. But it also talks about him coming down, looking at a front door, seeing that the front door was pried open, going down, I guess, to the basement and seeing his brother, and his brother saying, "Hey, someone is trying to break into the house," which kind of corroborates the story of his brother, Judge. So I don't think this Mr. Landrum had any type of weapon, any type of gun, any type of anything that would cause him to get anything other than personal bond, Judge. So that is what I'm asking for. And again, this case it's got to play itself out, throughout the system, Judge. We're not, saying it's getting dismissed today or going away, but let the facts fall where they may, Judge. And I think a personal bond in this Mr. Landrum's case can be sufficient with whatever conditions the court states. Again, I read the investigator's report. It doesn't talk about any assaultive behavior on this Mr. Landrum's part or anything of that nature. So I am asking for personal bond, Judge, on his behalf.
Any response, Council? Douglas?
No, Your Honor.
Thank you. Court's heard the representations, both sides. Court uses clear convincing evidence standard in this particular matter. The thing is that while this gentleman made some statements to the police and his co-defendant, his brother, defendant one, Mr. Landrum, and defendant one had a bulletproof vest. Okay. In this matter, there was no identification, okay, as to whether these two gentlemen were working together or not working together, but no identification as to the specific shooter. But supposedly, according to this gentleman, his brother is the one, defendant one, okay, that fired shots. Or he believed that the house belongs to his brother, and he believed that his brother fired shots. I'm not sure totally as to that. So the court is going to not go with $100,000 cash surety. The court is going to go with the $50,000 cash surety. This court does believe that it should be dealt with. And even if there is a mental order issue or some sort of incident, or there's a history, is that doesn't mean that this individual may or may not be dangerous. So
Judge, I'm
this court
sorry.
Is not aware of any flight risk.
Right.
Okay, but this court is taking into consideration is that both gentlemen were in the house. Okay, there was firearms. Defendant one had a bulletproof vest. This gentleman is saying is that his brother shot, and I'm not sure how much more that this defendant participated or didn't participate. So the court is going to go with a $50,000 cash surety. Okay, this court does believe that does believe that this person is a danger. Okay, how much of a danger? We'll let that play out for this Wednesday, February 19th, 2025, 9 o'clock in front of Judge McConicle, who'll look at the bond amount and bond conditions.
So Judge, what you're saying is that there was some shots that came out of the house, but you don't have any idea who shot.
I have that there's two individuals that were in the house.
You don't know who shot a gun, is what you're saying?
Okay. According to your client, defendant two says it was defendant one. Defendant one had a bulletproof vest. The defendant one did not say defendant one supposedly thought that somebody was breaking in. Okay. I'm not sure how much that defendant two had an impact because he made a statement saying, somebody's trying to break in the house. And I don't know if that was intentional, not intentional. I don't know. But I
You're
do
saying
find
that
him to be
Mr.
somewhat of a
Landry-
danger. I still believe that defendant two, in this case, he is somewhat of a danger, Council Reagan.
Okay.
That's why I'm going with the lower $50,000 cash surety, but he's still getting a bond redetermination for this Wednesday, February 19th. Mr. Landrum, you're gonna get another court date. It'll be this Wednesday, and you're gonna go in front of another judge. Do you understand that?
Yeah.
Okay, thank you, sir. You can step aside.
There's nothing that I did.
I'm still a little confused, Your Honor.
Okay,
Because you're saying he said that he thought somebody broke in the house, or he said that that's what his brother said.
counsel, we're finished with this. Thank you, though.
Yes, ma'am.
The gentleman, DDC, what's your name, sir?
Shot Roundtree, ma'am.
Is Rashad Paris Roundtree?
Yes, ma'am.
Roundtree, this is Magistrate H.F. Value here on a criminal matter, case number 250-5589-001, sir. You do have an attorney.
Your Honor, record on behalf of Mr. Roundtree, waive the formal reading stamp mute. He's been advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are February 24th, 2025. It is a probable cause conference followed by preliminary examination, March 3rd, 2025. Both matters are in front of Judge Shakay. Okay, Mr. Roundtree, some bond conditions. You're not to have any contact with the Lacey farmer. That means no person-to-person contacts or no contact to third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons like kitchen knives, pepper sprays, tasers. Do you understand those bond conditions, sir?
Yes, ma'am.
Okay. Council Douglas, go ahead.
Your Honor, for Mr. Roundtree, the people are going to ask for a bond of 50,000 cash or surety. Here we have concerns for safety, given that Mr. Roundtree allegedly was attacking and kicking this complaining witness who is 29 weeks pregnant with Mr. Roundtree's child. We have concerns that he allegedly told police that he had grabbed her, that he should quit drinking, and that he didn't remember everything that happened. Your Honor, we have the complaining witness saying that Mr. Roundtree actually threatened her with a knife, saying he didn't care that she was pregnant, and not letting her leave the house for some time, but then finally letting her leave the house to go to the hospital. So, Your Honor, that is what gives us concern for the safety here. We would note that there was a 2016 conviction for domestic violence. I'm not sure who the complaining witness was in that, and then the 2015 domestic violence, Your Honor. So this isn't the first time that he's been accused of being involved with violent behavior. And so at this time, we would also note that the officers indicate that when the complaining witness indicated which person was the defendant, that he tried to walk away from police even as they were telling him to stop so that they could investigate. So at this time, we're asking for 50,000 cash or surety with a tether to ensure safety of the complaining witness.
Thank you. Council Reagan, go ahead, please.
Yes, so Judge, he's arrested at the hospital while they were doing the ultrasound. He was arrested at the hospital, Judge. My client says he didn't make those statements, Judge. The police are trying to attribute statements that he never made. Judge, they don't live together. He lives somewhere else. He works every day, Judge. He has 7 kids. He only has 1 child with her. She's pregnant. I think that these allegations, Judge, and he says that they're not accurate. But he's obviously, needs to separate from her because she's doing some things right now and making allegations, Judge, that are putting his freedom at jeopardy. He says that this is not accurate. He's actually gonna go try to get a PPO against her because she's being aggressive towards him, Judge. Now I know that we talk about, her being 29 weeks pregnant and all that. But I don't know if that, I don't know what the situation is. I just know that he's not going to have contact with her. He doesn't want to have contact with her. So that's not going to be an issue. So safety of her is not going to be an issue. So I am asking for the personal bond. As Ms. Douglas said, there were some prior DV cases about 10 years ago, but nothing to my knowledge since, in the last 10 years or anything like that. So I am asking for personal bond on his behalf, Judge, with whatever conditions the court sets.
Thank you. Court's heard the representations from both sides, uses clear and convincing evidence standard when it's entertaining a monetary bond. Started out with a personal bond basis. Court read the allegations in the investigative report where when the complainant, Ms. Farmer, apparently went to the precinct yesterday, police saw some bruising on her face and her arms. Allegedly, and it does indicate that supposedly Mr. Roundtree made some statements. Whether or not that is recorded or not, don't know. Supposedly that he grabbed her, shouldn't be drinking. He doesn't remember the whole assault. They've been together in a relationship for 8 years, don't reside together. She's pregnant. Along with that, when he has some priors, domestic violence convictions, even though it's less than 10 years ago, you can make the argument, both sides can make the argument, she started it, he started it. One other bond condition for Mr. Roundtree, sir, there is no drinking of any alcoholic beverages. Do you understand that, sir?
Yes, ma'am.
Okay. Court is gonna go with $50,000 cash surety. Court does believe Mr. Roundtree is a danger, and I'm not sure if whether it's just drinking, because I don't know the other cases that he had, which are less than 10 years ago. But supposedly that drinking may have been involved in this case. Okay, so cash surety, it's unaffordable, correct, Counsel Reagan?
The bond, Judge, I'm sorry. You said what?
$50,000 cash surety, is it unaffordable?
That's unaffordable, Your Honor.
Thank you. And he's gonna get another court date for February 19th, this Wednesday, next week, at 9 o'clock in front of Judge McConicle, who will look at the bond amount and bond conditions. Based on everything, the court does believe that Mr. Roundtree is a danger. Thank you, Mr. Roundtree. That concludes your arraignment, sir.
Jesus, why?
DDC, that's it?
Yes, Your Honor, that is.
Thank you. You have a
Thank
good
you.
day.
You as well. Thank you.
Judge,
Thank you, Anna.
thank you, Your Honor.
Have a good day, folks.
See you tomorrow.
See you tomorrow.
See y'all.